In a Twitter fight with Bitcoin maximalists, Panos Makris supported XRP against claims that it was centralized and didn't matter, focusing on how many people use it. By the way, does US law say that SEC workers have to be fair? Last but not least, does Ripple's ownership of XRP come up in the SEC lawsuit? Follow me until the end to learn more. All of you, hello and welcome to our service, where we talk about what's new with XRP and the world of cryptocurrencies in general. If you are watching one of our movies for the first time, we will be happy to send you a special welcome. We want you to click the bell so that you never miss a movie. We're letting people know that this station is giving away 200 XRP. To have a chance at, you only need to subscribe to the channel and like this movie to take part. And leave a comment with the hashtag XRP hashtag. The winner will be revealed on June 30. The famous author of Understanding the Crypto Economy, Panos Makris, and Vlad Costia, a notable Bitcoin maximalist and influencer, got into a heated debate on Twitter about the legitimacy and usefulness of XRP, which is currently the 6th largest cryptocurrency by market capitalization. The argument started when Vlad Costia shared a harsh review of XRP and called it a bank coin with decreasing value. She was surprised that XRP was still at the top of the market. She said that its success was due to unit bias and the false belief that it was connected to the banking industry. Makris, one of the most influential people in the XRP community, laughed off Vlad Costia's claims and compared them to the idea that the Earth is flat. He was upset that such false information was still being spread in the internet age when there is so much information available. Makris sent a link to his article, Why XRP is the Most Misunderstood Cryptocurrency, to back up his claims. In the article, he explained XRP's technology in detail and busted popular myths. He also sent out a tweet that talked about how open XRP is, pointing out that it worked with open source code on public blockchains. Makris also said that XRP is used in a lot of different projects. He said that the XRP ledger is a base for hundreds of projects and tens of use cases. He told people to check out the official XRPL website to learn more about the different ways XRP could be used. Makris also talked about his earlier tweet, which said that XRP is for everyone and was made to break up banks' monopolies and make a payment system that is open and doesn't have a central point of control. Notably, the argument between Makris and Vlad Costia is just one of many that have been made about how decentralized XRP is. A week ago, Ripple's Chief Technology Officer, CTO, joined a conversation about a claim that XRP was not decentralized enough. Please don't forget to subscribe to our station and also hit that notification button bell to be the first person to find out more about what's going on with XRP. Ripple's general counsel, Stuart Alderoty, told an interesting fact about how the law says SEC officials should act. In the wake of what happened with William Hinman, Ripple's general counsel, Stuart Alderoty, told an interesting fact about how the law says SEC officials should act. Alderoty says that the law requires all government workers, but especially the people who work for the United States Securities and Exchange Commission, to be fair. The law asks, would a reasonable person, knowing the facts, question the employee's fairness? Alderoty added, the general counsel for Ripple also said that people now know what happened. He also talked about the fundamental duty of public service. Notably, this part talks about the general rules that apply to all employees and can be used to guide behavior. In the first section, it says that public service is a public trust that requires federal employees to put loyalty to the Constitution, ethical values, and the law above personal gain. In the part that Ripple's general counsel referred to, it says that are breaking the law or the ethical standards in this part. From a sensible person's point of view, it will be decided if certain events give the impression that the law or these standards have been broken. This has brought to light many secrets about the SEC. Remember that U.S. federal judge Sarah Netburn said that the SEC was being hypocritical in the way it handled the Ripple case. During the legal battle over Hinman's documents, it was reported that the SEC's first argument was that Hinman's speech didn't tell the market anything about whether or not the SEC would control crypto. After losing the first argument, the SEC said that the documents are protected by attorney-client privilege because Hinman asked the commission's lawyers for help while writing the speech. Based on the different claims, you could say that William Hinman, who used to run this SEC's Corporation of Finance, was biased when he wrote the speech. The documents were linked to a speech Hinman gave in 2018 in which he said that Ethereum and Bitcoin were not securities. During his speech, Hinman said that a token will no longer be considered a protection if it is decentralized enough. Documents show, however, that the infamous Hinman speech was meant to let Ethereum off the hook. This is what industry experts say. Hinman's first email about the speech while he was writing it was called the Ether speech. A few days before the speech, the previous head of the SEC also met Ethereum's co-founder, Vitalik Buterin. Many people think that Hinman might have been paid to give the speech because of these problems. Because of this, Ripple has asked the right people to look into it. Hinman to figure out what he meant by what he said in June 2018. Was the fact that Ripple owned XRP a part of the SEC lawsuit? The big question of the day is whether or not Ripple's ownership of XRP was a part of the SEC lawsuit. Please don't forget to subscribe to our station and also hit that notification button. Bell to be the first person to find out more about what's going on with XRP. A recent Twitter thread by John Deaton, the founder of Crypto Law and a lawyer who supports XRP, put light on what the US SEC's safe harbor proposal could mean. Deaton said that this plan could have helped bring clarity to the crypto industry and could have stopped Ripple and the SEC from going to court. A safe harbor plan, like the one put forward by SEC Commissioner Hester Peirce, would give token issuers some time to build their network without breaking federal securities laws. Deaton brought attention to the SEC's main worry by saying that if the regulatory body had focused on Ripple's percentage of ownership in the outstanding XRP token, it could have given Ripple a specific amount of time to reduce its holdings and meet the predetermined threshold. Deaton's comments came from his belief that the United States hasn't been able to keep up with the fast-changing crypto landscape because it doesn't have clear rules and a safe harbor framework. Deaton used a meeting between representatives of venture capital company Andreessen Horowitz and former SEC Director Bill Hinman on March 28, 2018, to show how important a safe harbor proposal is. He said that before the meeting, A16s had sent a detailed proposal for the safe harbor, which was originally made for Ethereum but could be used for other tokens as well. Deaton says that it's possible that this particular safe harbor proposal inspired Commissioner Peirce to come up with a similar proposal in 2020. In April 2021, she gave a second plan with 3 changes. Deaton stressed how Ripple, LBRI, and other crypto-focused companies could have benefited from a safe harbor approach. These companies could have gotten a notice with the exact criteria they needed to meet to show that they were decentralized. They would have had 3 to 5 years to meet these requirements and prove that their tokens were commodities. Deaton admitted that not everyone would have been happy with the suggested rules, but he said that having a clear framework would have helped companies like Ripple work toward meeting the requirements by a certain date. So it encourages both creativity and following the rules. Deaton says that the ongoing legal disagreement between Ripple and the SEC is partly caused by the lack of a safe harbor proposal and the lack of clear rules about token ownership. Deaton said that Ripple's move to sell some of its XRP holdings to pay for its legal fees showed that the company was serious about fighting the SEC's claims. If the SEC had set a clear limit for how many tokens a person could own, Ripple could have gradually lowered its shares over 3 to 5 years to match the limit. Jay Clayton and William Hinman, who used to be the director of the SEC, keep regulatory uncertainty going in the cryptocurrency business. The lawyer made it clear that it was everyone's job to figure out why the United States is so slow to create a clear and helpful regulatory environment for the cryptocurrency area. Guys, this video has come to an end. If you liked it, make sure to. If you like the movie, don't forget to sign up for the channel and click the bell to get updates. This helps me a lot with how YouTube works. Also, you can help others get as much out of this movie as you have by showing it to as many people as possible. Let's tell everyone about this, guys. If you are a real fan of cryptocurrency, you won't want to miss any of our information. We'll discuss the latest news that affects us all as a group tomorrow.